Welcome to the webinar. My name is Marty Shenkman. I'm joined by a friend and colleague from Green Bay, Wisconsin, Bob Keebler. Bob Keebler. We're going to talk. This is a part of an ongoing series on collaboration. I personally, professionally feel that collaboration is absolutely fundamental, essential, critical to all that we do in estate planning. The field is too broad, too wide, too complex. And even if one party to the collaborative process knows 10 times more than the other, it doesn't mean that the less capable partner is not going to come up with valuable insights or ideas just because they look at it from a different lens, from a different profession. So Bob is a CPA, works with attorneys all over the country, a lot of well-known ones. And we've collaborated together on lots of interesting matters, and Bob has been incredibly helpful. And that's what we're going to talk about, how to foster collaboration. And maybe, hopefully, you'll get some practical insights on how you as a CPA can collaborate better with estate planning attorneys, and you as an estate planning attorney can collaborate better with CPAs. Bob, before we start, do you want to say any general comments? And then I'm going to ask you about a letter that you mistakenly wrote, inappropriately wrote to an attorney long ago.
The important thing is we want to create a collaborative environment for the benefit of our clients. But also, I think and forgive me, I never go into these soft things, Marty, but for the mental health of everybody involved, the lawyer and the accountant, that collaborative environment, rather than two male bucks in the forest fighting each other over who's stronger or smarter, um, if you can get to a really good collaborative environment, it's a joy to go to work every day. And many of my lawyer friends and CPA friends will call me and say, I'm having trouble with this professional. Here's what's going on. And, we always then try to figure out what's the root cause of that and how do you create a collaborative environment where, it's just a joy when that person calls you.
It definitely leads to a better result. And I think, and I hate to use the M word, but the risk of malpractice is just so great in our allied profession of estate planning that if you have someone that can look at something fresh with a clean eye that hasn't been involved in the nitty-gritty, or someone that looks at it from a different lens because their professional experience is so different, it's really valuable. Because so often when you and I have worked together, I'll pick up something that you didn't think of. You'll pick up something I didn't think of. And neither of us care to be proprietary. We just want it done well and keep the client happy, get a good result, and certainly avoid any potholes for us. So, Bob, long ago, you wrote a really inappropriate letter to a client about estate planning. I think that's a good way to introduce the collaboration between the CPA and the attorney.
I'm not so sure the letter was inappropriate. I was at Price
Just,
Waterhouse. I
I'm
came
saying
up
that as
to
an estate planning attorney. I was offended by the letter.
But I came up to Green Bay, and one of the first projects I had was a physician who had a very large IRA back then, $2-3 million, which was a lot in an IRA in 1990. And I wrote a letter to his estate planning lawyer, who was in his early 70s at the time, the lawyer. And, and it was estate planning for Dr. and Mrs. X. And he blows up, he calls the managing partner of the firm, all upset about this letter that we're doing estate planning, and that was mended. And about 6 months later, a different client, same situation, but I titled the letter I titled it Financial and Income Tax Planning for Dr. and Mrs. Smith. And my phone rings and he goes, "Hey, this is so and so. Want to have lunch? I got your letter. We'll figure it out." And as long as I was respectful of his role, he was my best friend and he continued to send me a ton of work. And it just, we're in this situation where, and things march over time. They change, Marty. And, they're like, if you look at medicine, tremendous. This is why we're having these growing pains with financial advisors and with CPAs and lawyers. If you look at medicine, they didn't start PA programs and nurse practitioner programs until 1966. That's only 60 years ago, Marty. I mean, that's how long it takes for these things to work themselves out. So I think we need to be patient with some of these growing pains, but for the CPAs, I mean, always you're doing financial planning or you're doing income tax planning. Um, if the estate planning happens to be wrapped in there, that's fine. But um,
I think that the broader or generic message is we have to play nicely in the sandbox. We need to be respectful of each other. And I think the piece that goes wrong, and I saw an ad from one of the companies that's marketing estate planning software primarily to financial advisors. And I'm not going to mention their name, but the whole attitude of their email promoting this estate planning software um, was to financial advisors was you want to keep total control over the client. So here's how we're going to help you keep total control over a client. To me, that's a recipe for disaster. I don't want to be the big cheese. I don't want to have total control. I want to make sure the job is done the best way it can. And if there's more, if there's an income tax issue, I want to have the accountant involved. I mean, I think I worked as an accountant for a long time. I have an MBA with, a concentration in tax. I have some background, but I don't do the income tax planning that you do day in and day out for 40 years, 30 years. And with a financial advisor, I can't possibly do the forecasting and modeling they do. And again, like I said earlier, you never know which advisor just looking at something from a fresh, clean lens is going to look at it differently. So I think, the attitude of that email is where a lot of the problems come. Nobody should try to totally control the client. You want advisors working with you to get the better result. And one final point on that, I think the other place things go badly, especially for the clients, and I keep running into this brick wall. An advisor doesn't matter whether they're an insurance consultant or a financial advisor or accountant, the advisor talks to the client about something and they're approaching it in good faith from their lens as a planner and comes to the conclusion with the client that you need, and I had a call like this, an email like this a few weeks ago, you need a backdoor slat done in Georgia. Well, boy, that's a pretty detailed, prescriptive uh, decision. And why are you doing a backdoor slat in Georgia? And have you considered some of the other options? If any advisor leads the client to believe that they have the final and only conclusion, you're really shutting out everything. There's a famous quote from Sherlock Holmes, and I wish I could say it, but I don't remember it by heart. But it was something like, if you if you come to a conclusion, you're cutting off all the analysis and thinking that may get you to the better or the right conclusion. So I think it's important that any single advisor should leave the client with, hey, this backdoor slat in Georgia may solve your problems, but let's bring in the accountant and the attorney and talk about other options so we make sure this is the right idea. We just have to frame it a little differently because once a client is locked into something, it's very difficult to move them. And then you may not get the right result that the client needs.
what I've seen, Marty, is the lawyers are very receptive in 2025, 2026 to collaborating with CPAs when the collaboration is sincere and productive. Okay. Now, at the same time, what I'm seeing, and there's just some things on LinkedIn yesterday when I was flying back from a conference that I read that were quite fiery, but basically lawyers very aggressively questioning why financial planners are doing anything in the world of estate planning. And I never see that tenor with respect to CPAs. It's more so I think the financial advisors still have an uphill struggle. And what you said is important, prescriptive. If the financial advisor is prescriptive, like a medical doctor would be prescriptive to a pharmacist, then the lawyer is going to push back. The CPAs are going to push back. And it's changing so quickly. I was just at the AICPA's PFP symposium this week, and the observation of how quickly things are changing, it's overwhelming. It's not the speed change that we saw in the 80s, 90s, 2000s. It is one day you can do this and the next day you can do that. Now, The other thing that's out there, and it's important for lawyers and CPAs to understand this, is the financial planners, non-CPA, non-lawyer financial planners have feel very empowered and emboldened to do things way beyond the scope of their securities license. And that is something that, um, if channeled right, those growing pains will become a positive. But no one teaches it. Lawyers and CPAs go through this rigorous education, and in that education process, there's at least a little bit of training to collaborate with the other professions. Many financial advisors come in to this world not through the business school, but through some other way, and then re-gear at a midpoint in their career. They don't have that training, so they really don't know. They just don't have a academic sense of how to collaborate, and that we have to work on. We have to iron out that growing pain.
Bob, when we were preparing, you mentioned something about the evolution of the CPA's role. Let me just make one comment that seems to be the most obvious, but I think you have much more to say. Post OBA, one big, beautiful bill act, um, the emphasis for a significant majority of clients is on income tax planning, not just estate planning. And it's not that it was never on income tax planning, it was always important. But I think estate planning attorneys are becoming more aware. So I would think estate planning attorneys that have that limitation on they didn't get a background in accounting and tax, income tax, and didn't prepare returns. Without that background, I would think estate planning attorneys should be more open if they're prudent to protect themselves and their clients, they should be more open to collaborating with CPAs. But maybe you can talk a little broader about the evolution and start before just the recent bill.
Sure, if the world were totally black and white, and all lawyers did was estate tax, and all CPAs did was income tax, just a 1,000-foot fence between the two. OBA means that roughly 399 out of 400 families will not have to deal with an estate tax. So the planning becomes a lot of income tax. And for example, all the IRA rules, Marty, so many people call me, and well over 50%, sometimes 80% of their wealth is in their IRA and qualified plan. And how that works, the modeling that goes into that. Should we do Roth conversion? Should we buy insurance? Should we pay it to an EDB trust? I mean, those things are more on the CPA side, I would argue, than on the lawyer side. But if you create a collaborative environment, you'll get there from here. And we just need to be mindful of that. In 1990, when the exemption was 600,000, the lawyer skill set on the estate tax was sky high, because half the people they saw had an estate tax problem. And the CPAs were not doing as much because the lawyers were so good at it.
Why don't we use as an example? Obviously, we won't use names, but you and I collaborated on an interesting plan for an IRA. We had a client, just like you described, the vast majority of her wealth is in an IRA. She had two kids, and one kid is in the maximum bracket forevermore and is pretty wealthy, and the other kid has much less income, much less wealth. And what we had tried to do, we had looked at, I think, paying the wealthy child's share of the IRA to a CRT to try to defer the income tax for as long as possible. And it would have worked for him financially because he had enough wealth that he didn't care if he couldn't tap it for a while, and maybe have the IRA to the other son outright, or give him other assets in part. And we looked and you did projections on the CRT approach, and then you ended up doing projections on timing Roth conversions for the mother while she was alive at lower brackets. And one of the issues that we had was how to equalize the tax impact and the different bequests to the two sons. And even though you did all the forecasting, I think in the end, part of the problem was that we were worried about, not you and I, but the family and I, about how the impact of this complex plan could be on the family. And when you suggested the Roth conversions, it avoided all the interpersonal conflict issues, and that became the option they pursued. Maybe, I mean, that was to me an ideal example of collaboration.
There's two morals there. Or three things. One is
Do-
when you get
Can
into
you,
these very
can you
large,
say, can you discuss morality with attorneys?
of course, but one is running the numbers often leads you to a answer versus the subjective nature of just two people saying, I think we should do this and I think we should do this with no numbers. So the numbers often, my guys come in and they're debating what to do. I say, just run the numbers. I'll bet you the answer jumps off the page. And it's often what happens. Two is, in that case, the numbers just led us down a path. But what was more important is what Mrs. X was feeling, and that she didn't want to introduce all this complexity to her two sons.
Well, the complexity that could have led to conflict.
Yes, we were trying to avoid conflict. And that's more of a wisdom than knowledge thing. I mean, I think you picked up on, hey, we're headed down a path where these two men will be frustrated with each other with this plan or potentially frustrated. So
It
let's,
was a great plan. The numbers were awesome,
yeah,
but it
and
didn't
let's,
work for the people.
it didn't work for the people. And that's something that's very important. And I think this is something that we just have to work together on. And you do have to, maybe now's not quite the right time, but the other day I had a lawyer friend of mine from Green Bay come over and meet with a client who's worth about $75 million. And I went through the numbers, kind of laid out a little bit of what was going on, where the assets were. And then it's the wrong way to put it. I just told the client, now I'm going to let you and the lawyer meet for an hour or two, just use my conference room, but let's work on all the dispositive things because they have a blended family and it's quite complex. And I didn't really want to be in that room. I wanted that conversation to be lawyer to client. And something that's going terribly wrong from all my lectures to lawyers across the country is they come up to me and they go, what do I do about these financial advisors? They bring me, they lay out the plan, and I never even get a chance in their world. I don't even get a chance to talk to my client. I'm reduced to a pure scrivener, and they're incensed about it. And that's something we need to be very, very sensitive on.
Let me comment on that because I see the same situation. And to me, it's only a hairbreadth difference. The financial advisor, it's a wonderful role to be actively engaged in estate planning because you can bring up conversations that the client's not having with your attorney. But instead of ending it with, and I'll use the same silly example, and it was silly, you're going to do a backdoor splat in Georgia, which is possibly theoretically an answer, but I kind of doubt it. But why can't you leave it that, hey, here's a possible approach, but why don't we speak to your other advisors and see if there's anything better? So you've done all the same stuff, you're just framing it differently. And then the client and you can both be open to a better possible solution. But there's an issue for the attorneys that is really of critical importance. Um, Attorneys are ethically obligated to represent their clients. I'm forgetting the words of the model rules, but ethically, required to represent their clients uh, um, competently. And there's other words in some of the model rules. But if somebody comes to you, whether it's the insurance consultant, the accountant, the financial advisor, and says, do a backdoor slat in Georgia, and you simply draft a backdoor slat in Georgia without evaluating competently whether that's appropriate or not for the client, I think you have an ethics issue if that plan doesn't work out. So the attorney is being put in a very precarious position because how can you represent a client if you're merely being a scrivener for something someone told you to do?
Well, I think we would put the lawyer in a terrible spot.
It happens
And
all the time now.
you really have to, what you said is really appropriate. You have to walk around and look at the issue from the lawyer's standpoint.
and the accountant standpoint
Right,
and the wealth advisor standpoint.
but how would you feel if you were in their shoes and this prescription comes down? And and my lawyer friends will tell me, and I want to be kind here, but they'll call and say, this brand new financial advisor is writing a 5-page letter on what I should be doing. And it becomes a very difficult situation. So and that's why you need this to have this collaborative relationship. And some people would argue if everybody's under the same roof, you'd get a better result, but that creates all kinds of other ethical problems, which I think are greater.
I think theoretically, there could be theoretically more collaboration when everyone's under one roof. I really like the independence of an independent CPA, a financial firm, an attorney, a separate insurance consultant. I think that there's a risk and an issue, and I've seen it happen, of groupthink. So you can have a firm like a law firm that hires accountants to do all the tax returns, but are you really getting, I'm being too bold, forgive me, because I'm sure there's great law firms that have great accounting staffs that do great jobs on 1041s. But generally speaking, my experience is that when you have an independent firm, the groupthink that can happen within the culture of a larger firm where you bring in all the disciplines, you don't have, so you get more creative thought. And I find that when I bring in a new client and I look at what's going on with them, it's almost inevitable that we find something significant that just wasn't looked at. And that's not a criticism of the other professionals, the accountant or others. It's really just I'm the new kid on the block and I'm looking at it with a fresh eye. I think you can lose that a little bit within a firm where you have all the different disciplines. Bob, can we change gears? And if you want, you can introduce it. But I think it's important to talk about when we're talking about collaboration between estate planning attorneys and CPAs about a Covell letter. Why don't you explain what it is, talk about how it's been you've used it, and I have a few comments and questions that maybe we can discuss because I think sometimes they should be used and they're not, and I think other times they're kind of used too broadly to really fit within what Covell provides.
Sure. A Covell letter is after a specific case, federal case, and the goal is that a lawyer can hire someone else to help them give legal advice, okay? To help them understand the situation. For example, if you were a PI attorney and there was a very complex accident, you could hire a engineer to lay out what happened, okay? But it would be subject to your privilege, okay? And if you found out the engineer told you, hey, this is totally your guy's fault, if it's under a Covell letter, you can basically protect that analysis. Now, in the world of
Can you, I'm sorry to interrupt, but just to make sure somebody that may not be familiar, when you say protect the analysis, define what that means.
I think what it means is that the engineer could not be compelled to testify.
And his work product is not
His work product's also
accessible,
protected. Right,
correct, which can be very important.
right. Now, in the context of tax, it's easier to see in the world of divorce than it is in estate planning. But let me get to estate planning in a second. Divorce attorney X hires a CPA to help her build a spreadsheet of how this couple's going to divide their assets. Okay, that would be something that would fall under Covell. And
If you comply with the requirements.
if you comply with the requirements. Now, in the estate planning world, a lawyer hires a CPA because the gentleman has a $14 million IRA and the lawyer's looking for some ideas. Do we do a Roth conversion? Or during an estate administration, if you have choices, the lawyer might hire the CPA. And the goal is to bring that CPA expertise, make it available to the lawyer so the lawyer can give good, solid legal advice.
Sort of under the wing of the attorney, so it's protected.
Yes, that's exactly right.
So you've been hired under Covell letters. How does the process work? And make some comments about it for people that haven't. worked with that?
Sometimes I was just hired by somebody out of Boston. They wrote a letter to me, basically engaging me,
The attorney.
the attorney. Now, the word Covell relationship pursuant to case was in bold, so that if a judge was asked to throw it out, that judge would have to deal with that letter that makes it incredibly clear that we're trying to fall under Covell. Because sometimes the government will, pick around the edges of that. And you just don't, you want to make it very difficult for a federal judge to open that door.
One of the things we were talking about when we were preparing, I think, is apropos to the comment you just made about a judge picking around it. I've seen situations where the CPA may be hired to do five things. Three of those things may be reasonably arguable to be under the Covell construct, and two of them may not be. So you may actually better protect what's really important by narrowing the scope of what you're putting under the Covell. It may not cover the entire relationship. It may cover the things that you feel are important. Um, I think another concept that sometimes gets lost, and I'm going to pose a question which I've never really delved into, but your work has to be fundamental to what the attorney, or necessary to what the attorney's doing as an attorney. So if I have tax planning I'm doing and I need somebody to review a 1065, which I'm not that adept at because I haven't practiced as a CPA in 30 years, I can hire you to review the partnership return and give me insights. So it's got to be something that, and maybe you have better terminology than this. It's got to be like necessary for me to do my job as a lawyer to get that input from you. One of the terms that I've heard used, it's almost like if documents were in a different language and I needed to hire a translator because I don't read that language, I can't do my job without the translation. That's necessary. I think interpreting the income tax returns because I'm not active in that space is similar conceptually to translation. Maybe you give any other comments or insights on what is or is not appropriate to be protected?
Well, let's go to the extreme. Um, a business needs an audit, a financial statement audit for banks, etc., for the world to see. The lawyer tries to put that under a Covell arrangement. No way that's going to work. Okay. Now, on the other hand, lawyer is representing a family or a husband in a divorce. He hires a third party CPA that never did work for the people before to go through all kinds of documents, try to summarize them of what's there. For example, summarize the assets of these 25 trusts for me. Show me what's there. Who created the trust? What year was it created? What was
Income
originally
tax
funded? What did
status,
it grow to?
the
Forensics,
income tax status.
income tax status. Those things would clearly be a logical place for a lawyer to bring a CPA in under a Covell arrangement.
Bob, this may be so obvious that it's silly, but I just think it's important to say the retainer under the Covell arrangement should be done at the inception before you get started, if possible. I mean, sometimes you may have a preliminary discussion just to make sure you can handle the case, but you don't want to. I don't know. Can you do this after the fact? I've
No,
always
no, no,
thought
no.
you have to do it up front.
You probably can do it after the fact, but I think the healthiest thing to do is for you to call me and say, Bob, have you heard of the Sawyer family? And I go, who are the Sawyers? I don't know these folks. And then you say, I want to establish a Covell relationship with you. And everything from here forth is going to be under that Covell arrangement. And then I went through this the other day, and the lawyer says, how about if we meet in an hour? In the meantime, I'm going to send you an email just saying, I look forward to our call under a Covell arrangement. And, he hasn't told me anything until we have the word Covell in writing.
That makes a lot of sense. And I think sometimes people get so involved in trying to go forward, they forget to do that until later. And I appreciate your thought. I've not looked at that issue. Can you do it after the fact? But really, your phrase, the healthiest thing or the smartest thing to do is get it from inception.
I think so because I mean, in the last 60 months, we've seen from time to time in the legal news of the Department of Justice trying to pick away attorney-client privilege. And when they do that, that emboldens every lawyer in the whole process that, well, maybe I can get this out from underneath the privilege. And many times because of that, Marty, if ABC CPA firm is the incumbent, been doing work for years in something they need a Covell relationship, they'll hire XYZ firm under Covell and bring them in brand new. So all
Interesting.
the knowledge was under Covell because it's impossible. I learned this when we had our lectures on criminal tax in my practice and procedure class, that lawyer, attorney Robert Meldman, a legend in the criminal and civil world in Milwaukee, he said he would always bring in a new CPA because it was impossible for the old CPA to know what they learned when. Meaning, if you learn something over 20 years, but this Covell relationship is the last 6 months, what did you possibly pick up when? Where the brand new guy, hey, he just came on board. He couldn't have known anything that wasn't privileged.
That's a good point. Bob, one of the other topics that we chatted about before we got started, um, who, accountant attorney, who should or does prepare the 1041s, the 709s, the 706s, and any thoughts that you want to share on that?
Well, this has been an evolutionary thing. It varies greatly from jurisdiction to jurisdiction. For example, Cal CPA has done such a wonderful job with education. Virtually all that work in California is done by CPAs reviewed by lawyers. Now, on the other hand, you get to New York, New Jersey, Connecticut, Boston, or Massachusetts, more of that work is done by law firms. At least that's my sense of it. Okay. And so there's no clear line there. But I think most of the 1041s are done by CPAs. But though, there's tough issues. We just had one where we had to determine whether a clause was pecuniary or fractional,
That's
and
very, very
five different
nuanced.
lawyers were arguing about it.
Yeah,
And the tax results turned on whether it was pecuniary or fractional. So very important. The 709s, the best practice there in my mind is that in Mari, part of the evolution of this is that, just real quick story of I want to be very, very kind here, but in the 1930s through 1970 or 80, the lawyers were able to hire incredibly smart paralegals who hadn't gone to college, and they trained them how to do this tax work, and they did wonderful jobs. And today, we now call those people, professor, your honor, doctor. I mean, that glass ceiling is so broken, which is a good thing, that that level of talent maybe isn't available to every law firm in the country. I mean, that's what we've seen. And I know but I've seen that myself over time. So that work has drifted into the CPA world. And a lot of that is just the complexity of the tax code. Remember, you've seen how large the tax code has expanded since 86 to now in the last 40 years. And that's caused that work to be more specialized. On the 706 side, we do a 706 probably twice a month at least. And 100% of those are reviewed by the lawyer that's administering the estate. I mean, we would not even think about not having them look at it just to make sure everything makes sense to them.
not everybody is that prudent. We have found out the gift or estate tax returns were filed well after they were filed because the accountant never sent us a copy. And on one very large client, a large CPA firm did that, and the return was so wrong, fundamentally wrong. And I was actually very surprised that we had to have the accounting firm file an amended return. And my understanding is the statute doesn't begin to run until from the 3 years from the amended return. Is that correct?
That's a question for a proceduralist, but I think so. I think when you amend a return, you can restart the statute or restart part of the statute. Certainly, everything on that amended return is going to have a 3 year or 6 year statute.
But keep in mind what that does to now a Wandry or other type of adjustment mechanism. It's now open for another 3 years potentially. And if this return wasn't seen for several years, you could have now extended the statute by 5 years. That could wreak havoc with the plan and the protection for the client. It doesn't make sense to me whether you're an attorney, accountant, financial advisor. If you're preparing a return, get somebody else that has the expertise on the team to also look at it, because what if they catch something? Um, our practice in our firm, and in part it's because we're a very small firm, we have the accountants prepare all the returns. I made a decision long ago to jettison the preparation work that we used to do because I just felt that as the exemption went higher, the volume of returns was such that we couldn't be as cost effective in preparing them as a firm that had a full bench of staff to do it. And what we do is we review the returns. And our process is we send a letter to the accounting firm that prepared the return. And to date, I think only once, because the client was adamant, have I ever copied the client on it. I don't want to make the CPA preparer feel uncomfortable that I've pointed out issues to the client. So I just send my memo of review comments to the accounting firm and let them correct it. And again, with only one exception, has the client ever insisted on seeing that. And they were actually a gentleman about it and understood that, it's highly technical and there's different views. But I think that's a great way to do it. This way, the accountant is not uncomfortable. I'm not making them look bad, not trying to make them look bad. I'm trying to just be collegial. And I think it gets a better result for the client because everybody's working together well. So that's how we handle the review process.
The best collaboration is if you set up an inter vivos trust and you need a gift tax return, is for the lawyer to write a memo, like you're talking about, saying this is what they gave away. This was his property. This was her property. Goes on, so you know what to put on which gift tax returns. We want a gift split. We do not want a gift split. We want to allocate GST exemption. We do not want to make it very clear the communication that return is supposed to send to the government. I mean,
I'm going to tell you the process we use to communicate with the accountants the information they need for the gift tax return. But very important, when the attorney says you want a GST exempt, you don't want this, you do want this, that's helpful. The accountants love getting prescriptive, but you want an accountant that's really collaborating, not the lawyer equivalent to being a scrivener just preparing a tax return. You don't just want someone doing compilation work, you want somebody thinking about it. So if the accountant finds that they disagree with what's in the lawyer's letter, they should speak up. I've seen, and this is very, very dangerous, you don't want as an accountant to take that lawyer prescriptive letter and prepare a return without having the trust in your file. And you should look at the trust, not as a lawyer, but if it's a grantor trust, are there powers that make it a grantor trust? Are there powers that, if it's a non-grantor trust, is there a mistake somewhere in it that makes it a grantor trust when you think it's a non-grantor trust? So be careful with the prescriptions because depending on the expertise of the estate planner involved, some of those may or may not be right, and you may come up with a better idea.
See, and this is important for the lawyers to understand. Here's my opinion. If a lawyer gives an opinion on a pure matter of state law, which doesn't touch the tax code at all, the CPA should be able to blindly rely on that unless the advice is so bad that somebody coming out of their first business law class would go, that can't be right. I need to get another opinion. But when you get into the tax law, grantor trust, non-grantor trust, a lot of lawyers believe if they say it's so, it must be, and the CPA should just blindly follow them. Not true, because the tax law kind of lies between what the lawyer's doing and the CPA is doing. The CPA is doing the returns, the tax law is kind of in the middle, and the lawyer's doing the drafting. And the CPA has to have a copy of that trust, has to review it quickly to just prove to themselves it's a grantor trust or not grantor trust. And if the lawyer's already laid that out, under article blank, I've given the following four grantor trust powers. Then you're fine. Now, also
But you
remember,
should still look at the return because you may catch something the lawyer missed. And it doesn't, I don't think you're taking on the responsibility because you have the lawyer letter to rely on. However, look at the return. It should be in your file. You should have it.
yes, no, every once in a while we'll get into a discussion with the lawyer. Is this really a grantor trust or is this a portion trust where, it's 95% grantor, 5% non-grantor?
Or different
So,
grantors.
or different grantors. So it does require a lot of expertise. And what I'm finding is the complexity of the law now, like many big CPA firms have dropped their 1041 people into a different group from their 709 and 706 people. They viewed a friend of mine's in a firm like he runs the practice in a firm like this. They just view it as two separate skills. And the more I the more I see it, the more I see that they're right. I mean, they are totally right. You could spend literally, you could be doing 1041s on a full-time basis and still not know all the rules.
Oh, it's the complexity is incredible.
The,
But
the,
that complexity is exactly why I think it's so important to collaborate. Nobody, no matter how brilliant they are, can possibly know everything. You can't. You can't.
I do think it's very important though for the CPAs to this is what I've always done is to steer away from things that are pure legal that have nothing to do with numbers, finance, tax. For example, Marty, if we're in a meeting together and you're explaining healthcare documents, durable powers of attorney, I'm going to be a church mouse. I mean, there's no value I can add to that conversation. And it's a pure legal issue. Now, also, if you're administering an estate, helping to administer an estate, and the document says to my children, but the man has biological children, adopted children, stepchildren, it's not your job as a CPA to figure out what the word children means. Now, you might know, you might think you know, but just give that to the lawyer and get out of the way.
But by the way, that is such an incredibly complex issue defining descendants. And with the increasing sophistication of assisted reproductive technologies, it's getting more and more complex. Um, that's really complicated. That's
Well,
really complicated.
in just this class I was just at this week, long story short, gentleman leaves his property to his children. His wife had already died. And he was a Vietnam veteran. And sure enough, after he dies, a Vietnamese woman that was his daughter shows up. And she'd never been to the United States, but somehow she found out he died and hired a lawyer. They got their hands on the documents, and she received 1/3 of his estate. And that's something that, that could have been dealt with one way or the other.
Um, Let me repeat a comment I made earlier, and I want to give you two examples of where this collaboration can be very worrisome, and I'm seeing this accelerate. So I said earlier, one of the reasons this is so ill-defined, and it kind of has to be, is there's going to be situations where the wealth advisor or the accountant know more about estate planning than the attorney doing it. There's going to be situations where the attorney knows more about grantor trust, non-grantor trust issues than the accountant. So anything that we say is going to have to be adapted for the particular situation. And that's why there's no easy one size fits all answer on collaboration because the skill set levels can be different between different advisors and on different client matters. One of the things that I've seen, which is deeply worrisome, I had a gift tax return a client had prepared um, um, a number of years ago. I remember where I was sitting at my desk in my old office, in fact, when I was looking at the return. And I got the return and I called the CPA right away because there was no exhibit list and there were no exhibits. So I thought they just forgot to send me the exhibit list and the exhibits. The comment back from the accountant was, oh, we don't put exhibits on gift tax returns. What do you mean adequate disclosure with no exhibits? How do you even know what's going on with no exhibits? Apparently, what happened is the trust company that this person was working with handled gift tax returns and did it at a very reasonable price. And what I came to find out from the accountant was this accounting firm, small accounting firm in, call it the middle of nowhere, did all the gift tax returns for this trust company. So you may think that a well-known, reputable firm is handling some aspect of planning, and they may be outsourcing to somebody that has less expertise than another advisor on the team.
Well, I think that's very important. The other thing that the lawyers have
And
to
the
be
client
aware,
had no idea what was going on.
that's very much true, Marty. The other thing we lawyers need to be aware of, and you know, come to your own conclusions on this, but certified financial planners are starting to do more and more actual tax work.
And
Where they're,
document prep, like
yeah,
wills.
and I've seen them ghosting estate tax returns, ghosting fiduciary returns. They can't sign them, but they can ghost them. And the lawyer shouldn't let that practice occur. The lawyer should probably insist that somebody licensed to practice before the service, Internal Revenue Service, does that work.
But again, you may find the same thing that I described with this gift tax return, that the preparation work is being outsourced to a small firm in a backwater town that may not have great expertise, but is very low cost. And what kind of product are they getting? And is the firm, whatever it is, marking up the cost that they're paying? And what are they giving the client for that markup? And who's really doing the work? So it gets more and more complex. Bob, one of the things I said I would say, and I didn't, so let me just do it very quickly. What we try to do on any complex transaction is we prepare what we call a closing binder or a checklist. And what we do is we go through the time chronology of the entire transaction and we compile all the documents, which will go way beyond what a CPA will typically want to attach to a gift tax return. And I agree with that. Not at all, not all of it has to be attached, but we'll have all the background memorandum and schematics or the ones that are relevant to the plan. So there's a historical record so people can understand the thought process of the plan. We'll have, if it's setting up a new trust in, say, Nevada or South Dakota, we'll have the account opening documents and all the things filled out just so it's a complete record. If there's transfers between spouses, we'll have that because I like to see that reported on a gift tax return. So we arguably told the statute if they want to argue a step transaction doctrine. If typically when we set up an irrevocable trust, we'll have an initial seed gift just to get the account going, and then we'll do the transactions and the planning because now we know for sure the trust is really activated. There may be initial gifts, and then sometime later there may be a note sale or some other transaction. So we'll lay out all those documents and create an electronic binder with a table of contents. The top of the this checklist, we have a simple one paragraph explanation of what the client's doing. Because if you're the CPA, let's say you haven't been actively involved, which you should be, but if you're not, you can look, and even if you send it to a preparer, they can read that paragraph and get a mile high overview of what this is all about, which is very helpful before you dig into the detail. And one of the first things in that checklist that we have is what Bob said should be done a little earlier in the discussion, which is a summary of the trust, including its income tax status, GST status, completed gift, not completed gift, situs, all those things that you may need as the CPA to prepare whatever returns you're preparing. We try to summarize near the top of this checklist. So between the verbal little summary of the thing and then the sort of outline of key trust attributes, you have an awful lot to get going. And then you can pick and choose what you need for the exhibits to the return. And in fact, what I have found people often will do is we'll send them a Word document of the table of this checklist, and they'll extract from that and just paste it into what they create for a summary of the table of contents for the exhibits.
Marty, that's an absolute best practice. I've seen that done by the finest lawyers. They'll just summarize everything, make it very easy for somebody to get up to speed quickly.
Bob, we've covered everything that we had on our checklist for the program. Do you have any other thoughts? If not, maybe I'll let you summarize on collaboration between CPAs and estate planners.
I think from my perspective as a CPA, if I could talk to young CPAs, I'd say stay on the tax and finance side, stay away from pure legal issues, do not be prescriptive. When you write to the lawyer, talk about our mutual client, not my client, okay? I mean, you just have to, I know some of that's just like things we learned in kindergarten, but really think about how to create a positive relationship where the lawyer wants to talk to you and you want to talk to the lawyer. Because I've certainly in, 35 years seen enough of the two male bucks in the forest going at each other. And that just shortens everyone's life.
And it doesn't get the best result, nor does it protect any of the people involved from a potential malpractice claim. And it's not good for the client. It's not good for the advisors.
It's terrible for everyone. So Marty, I just think we're in this environment. Collaboration is here to stay. The tax code is so complicated, and no CPA can do their tax work without having the lawyer to help them with the state law issues, federal issues beyond tax. And also, quite honestly, there's situations where a smart CPA is going to say, wait a minute, this is something that is more procedural. There's constitutional issues. There's all kinds of issues that this is not something in the skill set of a CPA, but in the skill set of a lawyer who's kind of a proceduralist, somebody that litigates. And CPAs have to be willing to recognize those situations. Now, those are rare. I mean, I see something like that even in my practice once a month, not every week.
I think from the attorney standpoint, a smart CPA or a smart CPA firm that has different areas of expertise is invaluable to planning. I mean, even if you know QSBS, it doesn't mean you can't get a help in hand and different insights from an accounting firm. And you're doing 199A planning for qualified business income. A CPA firm is seeing it from a different lens and is going to have valuable input, the grantor, non-grantor trust status, all great things to talk about. I think involving the CPA from the inception of the plan, not leaving and relegating them to just be somebody filling out an income tax return, is beneficial for you as the estate planner. It's safer for you. It's likely in many cases to get a better result. On the flip side, I think it's important for both parties to the collaboration to really know their limits. There's some areas that the estate planning attorney may have great expertise and much better than the accountant, even if it's on a certain type of income tax issue. There may be areas that the accountant has better expertise on estate tax planning than the attorney. Just it shouldn't be about ego. It shouldn't be about being the big cheese or controlling the process. It should be about tapping the best resources available to help the client. And there's no shame in saying what you don't know. So I have a very large client, very interesting work, really loyal CPA who's been her advisor for years. He is certainly her confidant and most trusted advisor, and that's wonderful. He told me, which I don't see happen very often, that his firm really hasn't done sophisticated gift tax returns. We just completed a very nuanced, complex transaction. And I said, what I would do is recommend you hire Bob's firm to do the gift tax return. He's not going to step on your toes. He's not going to take the client. It's not in any way going to diminish your involvement with the client. And he said, that's great because we can't really do that return at the level the client needs. That to me is real true collaboration, and that's real loyalty to the client. So Bob's going to help. We're going to get the gift tax return done by Bob. We'll review it. We're going to involve the existing CPA and everything because I want him to understand all of what's going on. The client's going to get a better result. And this CPA, I said to the client, I called her up and I said, this guy is awesome. I don't see this happen very often. He really has integrity. And integrity is the most important attribute for a client to want to keep an advisor. So I'm done, Bob, unless you have any last words.
No, Marty, thank you. I hopefully we help people. And for the young CPAs, if you're struggling with this, I have some outlines that might help. You're more than welcome to reach out to me.
Thank you, everyone. And I hope this series on collaboration is helpful. I know it's non-technical, but I think that these collaboration issues are vital to how we all practice in serving our clients. Thank you for joining.